Well, good morning, folks. On behalf of the North Carolina Chamber and our President and CEO, Gary Salamito, we're grateful that you would take some time this morning to join with us as we hope to get some answers about this employer vaccine mandate that the administration put out a couple of weeks ago. We welcome you to this. This is a service of the North Carolina Chamber. It's one that we're happy to provide, and based on the feedback that we've gotten, it's one that the employer community has been hungry to get and hungry to see. I do want to mention a couple of housekeeping things before I set the stage. Number one, you all are muted to avoid distractions during today's presentation. Obviously, with several hundred people listening in, we don't want to overhear your phone calls or anything like that. Although maybe we do. Maybe that would also be interesting, but we'll try to save you from that embarrassment. Number two, we will answer questions that are put into the Q&A box. So I want to remind you, do not use the chat box for your questions. Please use the Q&A box instead. And you can upvote questions there so that we make sure we get the ones that are most meaningful to the largest group of people. Someone's already asked, will there be a recording of today's webinar? The answer is yes. And if you signed up through the email platform, you'll be getting that back in a couple of days, along with a summary of the webinar. And before I introduce Phil Strack, this is the stage setting. I cannot recall, and I talked with Gary Salamito about this here at the Chamber, and he couldn't recall, and trust me, he's been in the business a lot longer than I have. We cannot recall a period during which labor challenges have been as acute as they seem to be right now. To maybe sound a little bit hyperbolic, I think the need for employees, that situation is just literally on fire. The point here today is that on one hand, the mandate handed down by the federal administration is, I'm sure, an attempt to try to make that problem better. Many employers are concerned, though, that it's going to make the situation worse. So it's that balance and that conversation that we want to talk about a little bit today, whether this is dousing the flames with water or dousing them with something more that will make them actually burn hotter. And so we've got two perspectives on that. One is an experienced labor lawyer here in Raleigh, and the other, of course, is our Commissioner of Labor. We're going to start with Phil Strack, who is at Nelson Mullins, which has a national labor and employment law practice. Phil regularly advises clients on things like covenants not to compete. He litigates claims involving restrictive covenants, trade secrets, and other business litigation. So his experience is not just within the employment context, but certainly some specialty there. Phil also regularly defends management and employers in employment discrimination suits and counsels management on how to prevent or reduce the risk of those lawsuits. At being a lawyer by trade, I have a tendency to think we can look to other lawyers to give us guidance. And Phil, we don't just want to hear that the answer depends. We want some real answers this morning. Where do you see this? Where do you see it going? What's the current state of play? Provide us, if you will, and please go ahead and turn your camera on and put yourself off mute. But we look forward to hearing your comments, your guidance, your overview of what this thing's looking like at the moment. And thanks for being with us, Phil. We understand you've got a full plate, so it means a lot that you'd spend some time with us.
Absolutely. Thank you, Ray. It's good to be with everyone and to talk to you about this very important topic to a lot of people in the country. One thing I want to do is give you an overview of what the heck is actually at issue. What is an ETS? What's some historical context for this ETS, this emergency temporary standard that is the vaccine mandate? How have they fared in court in the past? And what's the current state of play with this particular ETS? So an emergency temporary standard as issued by OSHA is really, it's really just a procedural shortcut. It's a way for the government to impose a standard regarding workplace safety in a much quicker way, an easier way than what they would normally have to do through the normal notice and comment process that the government and other statutes require. So normally to get just a regular workplace safety standard through, the government has to show, OSHA has to show that there's a quote significant risk to workers by some something out there, and they have to go through a very long and rigorous notice and comment period to get that standard imposed. In order to impose an ETS, an emergency temporary standard, though, is a higher standard. The government has to show that there's a, quote, grave danger to workers from something. And so OSHA has taken the position that the COVID-19 disease is a, quote, grave danger to workers, despite how long it's been around, and that this is an emergency requiring them to impose this vaccine mandate. What's important is that an ETS can only be in effect for 6 months, and then the government has to take steps to actually impose it, go through the normal process to impose it for a longer period of time. You should know that the issuance of an ETS is very rare. In the history of OSHA, only 9 have been issued. So that's a very small number. This particular vaccine mandate will be ETS number 10. It will be the 10th one issued in the history of OSHA. The prior ETSs have not done well in court. Of the 9 that were issued, there were 6 that were challenged in court. Of those 6, 5 were struck down. So only one ETS that was challenged in the whole history of OSHA actually survived a lawsuit. That just underscores how high the standard is and how high the legal hurdles are for the government to impose a mandate like this. The prior litigation, I think, shed some light on how this ETS might fare in court. In 1973, there was an ETS regulating exposure to certain pesticides. The court struck that down because it found that there was not enough scientific evidence showing that the pesticides were a, quote, grave danger to employees. So it looked at the scientific evidence and said there's just not enough there. Another one in 1973 attempted to regulate certain allegedly carcinogenic chemicals. There were studies that showed that these chemicals cause cancer in rodents, but there were no human studies on human beings. And so the court said studies on rats are not enough to impose this kind of a standard. And so we're going to strike it down. Then there was a 1976 ETS on certain diving standards that the court struck down because it was prohibitively expensive. Then importantly, in 1983, the Fifth Circuit, which will become relevant to you in just a moment, addressed an ETS involving asbestos. And in that particular case, the Fifth Circuit said this mandate regarding asbestos regulation is the expenses of it outweigh the benefits to the regulated industry. And they also made it a point to note that the government took a long time to issue the standard. In other words, this asbestos problem had been around for a long time, and it took the government a long time to issue the standard. And the court said that undercut the government's argument that this was a, quote, emergency. So that case in particular and other cases like it are relevant today because with regard to this vaccine mandate, the Fifth Circuit Court of Appeals recently enjoined the standard. And now it's a lot more complicated than that. A group of states and some businesses filed a lawsuit in the Fifth Circuit and in several other circuits around the country, the Sixth Circuit, the 11th Circuit. These are the courts of appeals that hear matters coming up from the federal district courts. But the Fifth Circuit issued an injunction against the mandate. Now, what's going to happen next is this: because there's so many lawsuits filed all over the country, this thing that's created by law called the the panel on multi-district litigation, all these cases will be sent to it. It will literally have a lottery to decide which of these courts is going to decide the case. And then all these cases will go to that court. So the Fifth Circuit could get the case and could do whatever it's going to do, or the Fifth Circuit might have to send its case to some other circuit to be handled. And that circuit court could then modify or dissolve what the Fifth Circuit has done. So it is completely up in the air at the moment what the courts are going to do about this. I will tell you this, at the end of the day, the U.S. Supreme Court is going to have to weigh in on this and decide whether under the governing law the mandate is meets the grave danger standard. I think there are some very strong arguments that it does not, but there's obviously some pretty decent counter arguments to the contrary. And they'll also have to decide whether the fact that COVID was around for 2 years and the government's just now getting around to doing this undercuts the notion that this is a, quote, emergency that requires this sort of action by OSHA at this time. The litigation, my advice to clients right now is don't depend on the courts. Don't assume that the courts are going to strike this down. I think there's a pretty decent chance that they do, but don't assume that. And you should start taking steps to get ready for it, regardless of what OSHA does, the courts do. You should start taking steps to at least get ready for it, which means, reading the ETS, and notably the ETS requires every employer subject to it to have a written policy on this mandate and to distribute to employees. And there's a sample policy that OSHA has distributed. And the first thing you should be doing is reading that sample policy and then deciding how you may want to modify it for your own operations. And that's probably going to require the assistance of legal counsel, either inside or outside. But you should at least be taking a look at those sample policies and figuring out how you might apply it to your own business. So Ray, I think that's my time. I will turn it back over to you to hear who the people really want to hear from, and that's Commissioner Dobson. And then I will be happy to answer questions as we go along.
I appreciate that, Phil. Thanks for setting the stage for us. Do invite and remind folks to feel free to put questions in the box. I have looked at those that are there, and we'll work through those here in just a moment. Already some very good questions. I'm going to invite Commissioner Dobson to join us, and several of his staff are on, so you may see their block there on the Zoom screen. But a word or two about the commissioner first, and I guess let me start with a personal note, Commissioner, and that is a thank you for raising your hand for public service. It is an interesting time in the United States for someone to say, I'm willing to run for statewide office. We know that you were in the General Assembly for 8 years, did a great job there. And you said during the 2020 cycle, I'm going to run to be the Commissioner of Labor and look at some of these issues that are near and dear to me personally. And so thanks for doing that. It's not the best environment right now for folks to enter public service, so we're grateful. And then I think secondly, just grateful that you would take time to visit with us, not just the chamber, but with these 400 folks who have chimed in today and are listening to hear what you're going to say about how North Carolina is going to react to the ETS that's issued by the administration. You were sworn in this past January, so you've been in place all of about 10 months. And I do know that I am starting to see your face in more elevators, and so that's a good thing. But you come from Avery, McDowell, and Mitchell counties up in the foothills, if you will, or the edge of the mountains. You reside in a little town called Nebo, so maybe it's fitting that you're bringing us the commandments down, which is, I think that's where Moses got them a couple thousand years ago. And so also know you're a family man, have a daughter, and that you and your wife, Valerie, live there in what I call McDowell County. So bring us some wisdom this morning, Commissioner, from McDowell County. I think everyone's waiting with bated breath to see what it is that you're going to have to say. So thanks so much for doing this, and we look forward to hearing your comments.
Glad to be with you, Ray. I appreciate your friendship over the years, and appreciate the chamber inviting me and all your guests. So I want to start where I'm going to end, and then I'll lay out some other things. But Phil, very well laid out the lay of the land in the courts. It's in the Fifth Circuit, it's in the Eighth Circuit, and then there'll be a lottery. I mean, he articulated that far better than I could. So it's making its way through the courts now. But I want you to hear it from me. While it is going through the court system, the federal system, the North Carolina Department of Labor will take no action. We are not going to go forward with this like it's going to be in place, because I too think the courts will rule in our favor. And I do believe that'll be the case. So I want to be clear up front. While this is making its way through the court system, the North Carolina Department of Labor will take no action. I think feels accurate to say, if you want to start reading over, it's 490 pages. So it might take you a little bit to read over it, but I think it's perfectly fine to read over the ETS and look at what the standards actually say. But at least from my perspective here in North Carolina, while this thing is in the court, we are not going to take any action. So I wanted to start where I'm going to end at the end of my comments. So let me just kind of walk you through where we're at, what my opinion is. I always try to be on the level with any group that I'm talking to, and then kind of where I think we're going and what my options are, although they may be limited in the end. So I want to start by saying two things. One, I've been vaccinated. I've encouraged all of our employees to be vaccinated, so I'm not anti-vaccine. So I wanted to make that clear on the front end. And second, I don't like being in a position that makes it seem combative or looking for a fight. That's not my way of doing things, and that's certainly not how I campaigned. On the first ETS that Phil mentioned that came out earlier this year dealing with the healthcare industry, I adopted that readily from the Biden administration, very quickly adopted that. So it's not like I'm trying to be combative or I'm trying to pick a fight with the Federal Department of Labor. This is just the hand that we've been dealt, and this is what we're dealing with. So those two things I wanted to make sure up front. I've been vaccinated. I support vaccines. Second, I'm not trying to be combative with the Biden administration. But I want to tell you why I'm opposed to this and why I think it's bad policy and why I think it's wrong for North Carolina. One, Ray laid out early on in his comments, we are facing probably the greatest crisis with the labor force in a generation, if not more. Very unique and unprecedented times. I've heard from rural school boards and urban businesses that have said, if this goes into place, we will lose at least 10% of our workforce. That will just say, I'm done, I'll figure something else out. I'll go to a competitor that doesn't have to meet the 100 employee threshold or doesn't meet it, but whatever, you'll have to walk me out of here. And with the crisis that we're facing, this is only going to exacerbate that. And that's where I think the Biden administration has failed, because I don't think they took that into consideration or didn't listen to the business community out there, because that is a real problem. That's not a chicken little skies falling. That is a real problem that businesses, both private and public sector, are going to face. So it's only going to exacerbate what already is a crisis, maybe to the breaking point. Second, in that 490-page emergency temporary standard was not one additional dollar for my department to enforce this. So they want me to take this on in addition to all the other duties that our compliance officers are doing without any new resources or any new compliance officers to help enforce that. That to me is fundamentally unfair and wrong. Again, I think that they did not take the right approach and did not clearly think that out. And third, I just try to be honest with any group. I think it's fundamentally unfair. I think it is fundamentally unfair. The nurses and EMS workers and firefighters and people that have worked on the lines all across this state who have chosen not to get vaccinated for whatever reason, forcing them, when they've been on the front lines for the last 2 years, forcing them to either take a vaccine or lose their job. I can't think of anything more fundamentally unfair than that. So for those three reasons, I'm strongly opposed to this. And the more I read and the more I study, the more opposed to it I am. So as long as this thing's working its way through the courts, I'm not going to take any action. And the North Carolina Department of Labor will not take any action. So where does that leave us? What do you say? I know the question is going to be, okay, what if the courts, as Phil said and Red exactly said, that this may end up not being in my favor and it is ruled constitutional? My options are limited. North Carolina is a state plan state, which means we run our own OSHA program, but I don't have full authority to say yes or no. And to give you an example of that, the first emergency temporary standard that I adopted, there were some states who chose not to adopt that. The federal government has already started the process to revoke their state plan status, which means they would lose their ability to monitor and regulate workplace safety, and the federal government would come in and take over their OSHA program. And that very well could happen with this thing going forward. So that's what I'm faced with is a very bad situation if this thing is ruled constitutional, where I have some options and I'm looking at some options to try to get to the federal government to allow me to do some things that is unique to North Carolina. But I don't know that they're going to accept that. I hope that's the case. And if they don't, then I'll have to make a decision at that point on what the Department of Labor will do with more information. But I'll be honest with you, I don't know what the Department of Labor will do if this thing is ruled constitutional, because I'm so opposed to it. But at the same time, I'm faced with a decision of possibly losing our state plan status or accepting this vaccine mandate. So it's a very precarious situation, and I've not made a decision yet on if this thing is ruled constitutional. So that's what we're dealing with. I think it is fine to start looking over this and kind of be prepared if it comes to that. But I'm telling you up front, we are not going to enforce this while this thing is making its way through the court. So we're going to wait to see and hope that is the case. So Ray, that's really where we're at. That's my opinion. That's where we're at as a department. And I look forward to the questions.
Thank you, Commissioner. I think you might have just made some news. So we'll see how long it takes for your comments to hit the Twitter sphere out there. But you answered, frankly, a number of questions. And Phil, I would invite you back on with your camera and let's take some of these questions and work through them. You talked, Phil, said it's smart, and I think the commissioner repeated that. Take a look at the rule, take a look at what could happen if it does go into effect. What specifically, given what the commissioner has just said, that he's going to wait and see what the courts do, what is your advice then to these folks on the call as an attorney? And let me just do some of the dirty work here. This is obviously just a webinar where we are discussing issues at a very high level. No one here has created an attorney-client relationship with anybody that's posing a question or that's participating in the call. We are simply talking at a high level, Phil. What are the 1, 2, 3 steps that maybe you would tell some of these folks if they did become their client, or just sort of hypothetically? Take that away a minute.
Yeah, I would, we don't know what the courts are going to do. I think the commissioner has a very reasonable position, and I would support that. And I think, but if you're an employer potentially subject to this, I think the real mandate kind of hits January 4th or somewhere thereabouts. And so what I tell my clients is what I tell everybody else is just, basically prepare for the worst. That's what, lawyers make sure that their clients are prepared for the worst, for the end game. And the way to do that is to read the ETS. It's 490 pages, as the commissioner noted. It's crazy long, took me forever to get through it. And it's got all kind of jargon, et cetera, but you should at least read through it. And then if you Google OSHA sample vaccine policy, the sample vaccine policy that federal OSHA will require if this thing ends up going into effect will pop up. And you should start taking a look at that, and you can literally kind of see how it's laid out. And you can see, if I have to comply with this, am I, what do I need to tweak this? Do I need to just implement this fully? You should take note of the fact that the mandate is you got to get the vaccine or you got to submit to weekly testing. So you got to figure out how am I going to actually implement that? How am I going to enforce that? How am I going to know? And that's frankly where you're going to have to get some outside advice, because there's tricky, privacy issues in terms of how you collect this information, where you store it, what you do with it. And so you got to start figuring that out. I've had a lot of clients already calling me about, hey, I have I have separate entities, separate LLCs that each may have 20 employees, but am I going to be subject because all of them combined have, 120 employees? You may or may not. If you have a central HR function, you probably will be covered. If you don't, you may not. So you have to start thinking about and getting some advice on, okay, what's this thing going to look like for me? Another thing I would probably do is I would, whether formally or informally, I would start trying to make an assessment on how's this going to impact my business operations if I have to do this. I'd start figuring out from my employees who, at least informally, it's perfectly okay to ask employees if they've had the vaccine. There's nothing illegal about that. It's perfectly okay to ask. And it's perfectly okay to say, hey, have you had it? What would you do if we had to do this? Are you gonna, how many people are gonna leave? What's gonna be the impact? I think the commissioner is very correct that this could have widespread impact. There's a vaccine mandate, but the weekly testing, but there's a lot of people out there that don't want to submit to a weekly test. They're just not going to do that. And they're going to go find a place where they don't have to do that. That's the reality. That's called voting with your feet. And that's what people do. And so I think it's smart now for people to start just asking around and figuring out what the impact on the business is going to be so you can be prepared for that. So
Phil, let me jump in. And first of all, a comment, just an advertisement. The reason we ask you to be on this call is not only because of your employment law expertise. Phil actually chairs the Chamber's Employee Issues Committee. Our committee, we call it Workforce Issues or Workplace Issues Committee. He's done that now for several years. And so, Phil, you're really our sounding board internally when we see an issue like this. And that's how we ended up putting you in this role this morning. So again, thanks for doing that. I should have mentioned that early. In fact, you answered a different question, Phil, and that was, as an employer, am I even allowed to know the vaccination status of my employees? And this ETS makes clear not only are you allowed, you are required to know that status. I mean, actually, that's exactly what it says. You touched on the time, the cost, but I thought Commissioner Dobson had a great point about cost as well. Commissioner, you've got some things to think through if this comes down and it ends up, being enforced. Who are the employers that are subject to it? How do you get to them? How do you receive complaints? Can you talk about, because I think that taking you at your word, that is part of what you said as to why you're hesitant to take this thing hook, line, and sinker the way it's been presented, that there's a lot of logistical challenges that would be given to the department with no additional funding, which is ironic given all the money that's come out of Washington over the last 18 months. Talk a little more specifically about that and what that would mean on a day-to-day basis for your department and kind of the strain that you were referring to there.
Sure. I will answer that, but I will preface and say that I'm not in a position to say that we are going to move forward with it. So everything will be based on a hypothetical if in the end this happens, but I am not even close to making that decision for North Carolina, no matter the consequences. So I'm not even close to do that. But to answer your question, we conservatively see roughly around 6,000 plus businesses that will be affected by this, and roughly 1.2 million, conservative estimates are 1.2 million North Carolinians who will be faced with this. And typically how we do things in this unique circumstances, as Phil said, we don't have a lot of practice with this because only 10 in OSHA's history and only 1 in my tenure. If we get a complaint on something that is not being done, let me just use ETS, the healthcare standard, as an example and stay away from this vaccine mandate because I'm not ready to go there yet. So I'll use that on how we enforce that. If we get a complaint from the workforce to our system, we will then research that complaint, investigate, and then if it's warranted, go out to the site and investigate. Most of that has been reactive to complaints. We have done some proactive inspections based on ETS, the first ETS that we've had to enforce, but most of it has been reactive to complaints. And with the magnitude of this, I would have to think through it. But whether it's the North Carolina Department of Labor or the U.S. Department of Labor that ends up enforcing this, if it doesn't rule favorably in the court, I don't see how you could do it any other way. I don't see how you could do it other than on a reactive basis, because I have 114 roughly compliance officer positions allotted, responsible for 1.2 million workers that will be affected in 6,000 businesses. So, that I wish I could give more on that, Ray, but the limited information we have now, that's as much as I want to say at this point.
Yeah, Commissioner, I hear you. I hear sort of two things. One of them is we'll cross that bridge when we get to it, and you want more time and are going to be taking some input on where to go. Are there any hard deadlines, given that the court has now stayed the federal mandate, at least for the time being? Are there any markers in your mind in a chronological sense?
So I would respectfully ask Phil to weigh in on this as well. I would just say that I have 15 days from the day that it dropped, which was last Thursday. So I think I've got until next week to respond in my 15 days. But then the drop dead deadline is January 4th, as most of your clientele probably knows. But that's all contingent on how the court cases go. I would defer to Phil on this, but I would think that they would respond even with the lottery relatively quickly, knowing that January 4th date is approaching. But Ray, with your indulgence, maybe ask Phil that.
Yeah, sure. Phil, comments, jump in there.
Yeah, absolutely. So the multi-district panel is, I believe they're going to take some action by November 16th to consolidate all these cases into one circuit court. And so that's obviously coming up shortly. I would anticipate whatever court gets this is going to take action pretty quickly. And then what will happen is it'll go, let's say a court enters an injunction, that'll then go straight to the U.S. Supreme Court to decide whether to touch the injunction or not. If an injunction is denied, that'll probably go up to the U.S. Supreme Court to decide whether to impose an injunction. And my personal feeling is if an injunction is issued, it's very easy for the Supreme Court to not touch that injunction, just take no action on it, not mess with it. If no injunction is entered, it's much harder for the U.S. Supreme Court to then itself affirmatively say, hey, enter an injunction. So a lot is going to be determined based on what the circuit court does with it. And on this issue of resources, I think it's important to note, during the COVID era, there have been a lot of complaints just filed about COVID in general, right? So you got all these complaints that are always getting filed. We've handled lots of them about, the workplace isn't safe, they're not cleaning enough, blah, blah, blah. And so the commission, the department's already dealing with a ton of COVID related issues. This is just going to, put all that on top of that.
That's right.
Let me stay with, did you have a comment there,
no,
Commissioner?
Just agreeing.
Yeah. Phil, let's stay on this legal focus, because for better or for worse, it seems like that's where a lot of this is going to be decided. I mean, I'm not asking these questions just because I'm also a legal nerd and interested in the response. I actually think this is where this is going to be decided. You mentioned a term of art there, multi-district litigation. What does that mean? I mean, are all these cases being consolidated in one place, or how does that work? And then, frankly, I'm going to come back and we're going to talk a little bit about how we count to 100 and unpack some of that. But let's start with just multi-district litigation. What that even means, is that in fact the way you think this is going to move up in the court system? And then if you would go back, Phil, and I can ask the question again in a moment, but remind us what you think the tests will be. You talked about that some, that this is an extraordinary remedy that the department has. How is a court going to actually evaluate that? So MDL, and then maybe what the tests really are going to be.
Yeah, the multi-district litigation panel it's created by statute, and it's designed to ensure that you don't have a bunch of cases going on around the country at the same time and overwhelm the judiciary with those cases. And you typically see those in asbestos cases, opioid litigation, this type of thing. This panel comes together, puts all the cases in one court, which then handles all of them to then go up to the U.S. Supreme Court. And so, yeah, I think that's how it's going to be resolved. I think that panel is going to use a lottery system to pick which circuit court gets to handle this case. What the law says that once that panel picks the circuit, the other circuits are it's mandatory they send their case, that they transfer their case to the circuit that's picked. So what will be interesting, let's say the 8th Circuit gets picked, or the 11th Circuit, or the DC Circuit. The 5th Circuit's already taken some action here. They're clearly interested in this case. Will they send their case to the panel that's picked if they're not the panel? Or will they say, no, thank you. We're a separate independent court of appeals. We're going to do what we want to do, and we'll let the U.S. Supreme Court sort it out. That'll be very interesting. Normally, you don't have that kind of issue. The other courts send their cases to the lottery pick court, and it's all said and done. I could frankly see a scenario where the 5th Circuit could beg to differ on that and take a contrary interpretation of the statute, of the MDL statute. But that remains to be seen. We'll see how that plays out. Ultimately, the U.S. Supreme Court's going to have to weigh in. But on the standard itself, whether something poses a grave danger is a very high standard. There's just no doubt that that's a very high standard, and it's got to be something. Obviously, COVID can kill. There's no doubt about that. That's why we encourage people to get vaccines. It's why, as the commissioner stated, I'm fully vaccinated. I certainly don't want to have adverse consequences from COVID. There's no doubt about it. But we also know that there's a lot of data and science about COVID that's known now that wasn't known before, that presents and paints a fuller picture of the threat of COVID, who it actually threats, who it actually is not a threat to, and how it works. And so I think the court that gets this is going to, do a deep dive into, how dangerous is COVID, who is it dangerous to, and as a consequence, is a nationwide mandate for employers with 100 employees, does it make sense in light of the dangers of COVID, or is it more or less arbitrary? There's been a lot of discussion about why 100, why not 200, why not 300, why not 50, why not 76? Who knows where that number came from? It was a probably kind of picked out of thin air. And so there's going to be, the court's going to, I think, going to have some hard questions about, does this standard make sense in light of the danger that COVID does present to certain segments of the population? The other question that I think that this is going to turn on is the timing issue. This is supposed to be an emergency standard. This means something has developed suddenly that OSHA has got to address immediately to abate a workplace hazard ASAP. And we all know that COVID's been around for a long time. And so the court's gonna have some pretty hard questions about why now? Why not, why not a year ago? Why not a year and a half ago? Why now? And since you've waited so long, in light of the fact that you've waited so long, is the standard you're imposing too much, or should it be more nuanced or more limited, given that COVID's been around and people have learned how to figure out COVID on their own, and for the most part? And so should you have instead focused on certain industries or certain types of employers where there's been real problems, where there's been outbreaks and this sort of thing? And is this sort of nationwide kind of mandate on everybody appropriate? So I think those are going to be the two areas that you're going to see significantly litigated on this thing.
Well, you mentioned, and there's an old joke, I think, among lawyers, when you get to these tests about, does this make sense? Is this reasonable? we kind of say, you know, who gets to decide, and that's the reasonable appellate court judge. And that's a tough place for an employer to be, having to wait to have a court to tell them whether something's reasonable or not. Commissioner, I want to come back to you, and we're going to unpack this. How do you count to 100 question? Several people have asked that. Let me start with you. And I heard you loud and clear that the department is not prepared to take action on this, at least at the moment. With that said, do you have a system already that has a database of our employers that have 100 employees that would be subject? What is that thought process? And in fact, is that sort of part of your thought process, that the complications there are feeding in? I mean, what's your response on the 100 question?
It is. It would be a lot to untangle for sure. We were able to get the estimates based on loose data that shows that 1.2 million workers, 6,000 plus businesses. So we can have access to we will have access to the information, but how you facilitate that, who it applies to, who it doesn't apply to. I've seen in some of your questions already, you know, do volunteers count? The way I read the pages, volunteers will not count because that's not employees, but do substitute part-time teachers count? They would count in that 100 number. So untangling all those questions, I don't think you can just say a blanket, this is how it's going to be. I think you have to take each question one by one in each different circumstance. But the short answer on your broader question is yes, there is a process to figure all that out. We have different data points that we can look at, but it would take some time to untangle that and then get the word out to notify those that would fall under this and those that don't. Two other points that I would like to make, if I can. One, I want to be clear. I've probably gotten 4,500 emails telling me to not implement this here in North Carolina. And if it were as simple as me saying yes or no, I would have already said no. But I want your viewers and North Carolina as a whole to know there are consequences, whether in the end I say yes or no. If I say yes and adopt it, I would be going against everything that I fundamentally disagree with and have to have my compliance officers implement it. If I say no, which is what's in my heart and what I'm thinking that is the right thing to do to not administer this, then the federal government has shown a propensity to come in and revoke your state plan status and say, we'll not only do vaccine mandates, we'll take over your whole program and you'll be relegated to not having workplace safety. So I want to reiterate, I'm doing all that I can, but it's not a simple, I can say yes or no to this. So I wanted to make that. One last point as a side note to that, on the way that this was implemented, if employers can put this weekly cost of testing onto the employee, which is a roughly $100. My best rough estimate is about $100 a week. And if you're in Western North Carolina or Eastern North Carolina, as you know, making $45,000 a year, $100 a week adds up over time. So to say that that's a choice, like the Biden administration is saying, is unfair and naive as well, because I don't view that as a choice to say, well, you can get tested. Well, you can for $100 a week. Roughly. So those 2 points I wanted to make in addition to answer your question.
Yeah, no, that's great feedback, and please jump in anytime. I think folks rather hear what's on your mind than necessarily work through all the questions. But I do want to spend some time because there have been several questions about the getting to 100. Let me start that discussion, and then you two just chime in. My understanding is that, and again, our understanding, this is our interpretation, although I do think the ETS is pretty explicit on some of this. Part-time and seasonal employees do count toward the 100. Independent contractors do not. Staffing agency temps do not, but keep in mind, they are probably working for an agency that has over 100 employees, so they may be subject at their home employer, if you will. Volunteers, I thought that was a great question. Commissioner, your take was that they would not count. And then there's also this weird dichotomy that someone may count for purposes of the 100, but they may not be required to get vaccinated. So that kind of pulls in the company that has 103 employees with 90 of them working at home. Apparently the remaining 13 are subject, but the ones that are staying at home are not subject, but they're still, you know, the company itself is subject. Can you bring any sense to that? And we'll start with Phil. I mean, is there a guidepost? Is there a theme there that would help us unpack some of this question, sort of a rule of thumb?
No, it's going to be complicated. You'll recall when the law passed last April, which required employers, I think it was under 500. I can't remember the threshold now, to provide paid leave for people that had COVID symptoms, et cetera, all that. That'll be some guidance in terms of how to count, because there were some rules that got developed about how to count. There was some litigation over that. But it's just going to be complicated. It's going to be literally each employer is going to have to sit down with the rule and try to figure it out, because you make a good point. You know, people that work exclusively from home don't count. People who work exclusively outside don't count. But what does it mean to work exclusively outside? I don't know. Sometimes you know, how often you come to the office? Do you report into the branch every day? Occasionally, does that count? There are lots of people that work from home 90% of the time, but maybe not 100% of the time. Is that going to count? How's that going to work? So there are going to be tricky threshold issues that honestly each employer is going to have to look at on a case-by-case basis. I don't think that there's going to be a way to like put a just sort of a broad rule and say, okay, everybody, if you follow this, you're good to go. I think the workplace has changed so much over the last 2 years, and where people work and how they work, that each employer is going to have to figure this out individually.
Commissioner, you're welcome to chime in, or I can go to another question. Any comments or thoughts there on the how do we get to 100 and the confusion that's creating?
I think Phil articulated it very well. I did put my email in the chat box if there are other specific questions, if we don't get to all of them, because there's going to be so many of those. Staffing, independent contractors, who counts, what constitutes never going in the office if you work outside, because it's 100%, not 90%. A lot of different minutia and nuance there that we're still sorting through. So I'll leave it at that for now, but we can get specific answers on some of those. So
let me just reiterate that. It sounds like Commissioner likes emails. He's already gotten over 4,500, he said, and he's put his email address out there. And that's just a thank you, Commissioner, because I think folks really want to chime in here and have thoughts and feelings about that. So we'll make sure when we do our summation and circulate the video that we also provide that as a link that folks can reach you. I'm looking through the questions. I think we've touched on a lot of them. I think this outdoor independent contractor question is going to be one that folks are going to frankly need some individualized advice on. So I won't repeat that one.
Ray, I had a couple that I saw, if it's okay, if I can.
Yeah, please jump in, Commissioner. Thank you.
One, there was a question asked, can an employer do this on their own outside of the ETS just as a company policy? And the answer is yes to that. And some have already done that across North Carolina, and there's nothing that would stop that. Second, I saw a question about why doesn't North Carolina join the lawsuit that's going on? A couple reasons on that. One, North Carolina is unique. Almost every other state, the Commissioner of Labor answers to the governor. And that is not the case in North Carolina. It is a completely separate body. It's a separate department that is completely independent from the governor. So I don't answer to the governor, and it's completely separate, which is far different than other states. So I wanted to make that point. In addition to that, those other states, if I was to join the lawsuit, you have to have a like-minded attorney general who would file that lawsuit on behalf of the department. That's traditionally how that works. And although we're friends, on a personal basis, that's just not going to happen. So we don't have the opportunity to join that lawsuit through the normal protocol. So I wanted to throw that out there as well.
Yeah, we're in a unique place here in North Carolina. It's, well, not completely unique to us, but our Council of State form of government certainly disperses, if you will, the executive branch power across the people a little bit more with more elections. And so that creates these conundrums that you just talked about. So appreciate you mentioning that and touching on that. It does look like there are a lot of questions about payment. I don't know the answers to those. You may not be comfortable answering those, but Phil, can you maybe give us the highlights or your impressions at the moment? On one hand, we've talked about how employers are certainly not given any money from the federal government to help pull this off. Even the Department of Labor here in the state's not giving any money to help pull it off. Who, if you've got a person that wants to test as opposed to get vaccinated, who is responsible for paying for that? Because as Commissioner points out, it can get expensive. What's your take, or is that still an open question?
Yeah, I mean, the employer can pay it, or it can require the employee to pay it. So employers are going to have to make a tough employee relations call on that. That's going to put a lot of employers in a bind. I mean, it's a tough call to make. If you've got over 100 employees, that could get pretty expensive pretty quickly. And the other issue I think that people are going to have to deal with is you have to allow for paid time off to get the vaccine. So that adds another layer of sort of complexity to an employer's day-to-day operations, because most employers have PTO or sick leave or whatever, but now they have to code a new form of leave for employees to go out, and I think they get 4 hours to get the vaccine, and so that's going to add another layer of complexity. We all remember when Congress passed the law last year allowing for paid leave for COVID symptoms. I mean, my phone rang off the hook for a long time as people were working through that and trying to figure out how to implement it. It was very complicated for a lot of people. And I predict it'll be complicated this time around too, if this thing goes into effect.
Well, we're down to about 7 minutes left. A couple more questions, and then I'm going to let each of you have sort of the last word, and we'll start on that with Phil, and then let the commissioner wrap us up. But a couple more quick questions, I think. Someone said 100 employees in one location or 100 overall. I think that is pretty clear that it's 100 overall, isn't it? Even if they're in 30 locations, is that right, Phil?
Yeah, it's overall. Doesn't matter where they are. The only exceptions are this working from home or working outside type thing. It's overall. So it's unlike every employer that's got 100 employees is also subject to the Family Medical Leave Act, which applies to employers with 50. That has a radius requirement built into it, where if you have people that are spread apart, then it may not apply to you, even though you have 50 overall employees. As I read it, that's not the case with this standard. If you got 100, you got 100.
And Commissioner, you might even be interested in chiming in on this one. I know one person said, look, this is a federal regulatory mandate. Is that the same thing as a law? I mean, is this just recommendations from the federal government, or is this in fact the law of the land? What's your take on that, both of you?
If it goes into effect, if it goes into effect, I don't think I'd want to be the guinea pig to decide, now I'm going to ignore this thing and take on the fines and then go sue. I mean, any employer that wants to do that could do that. They could say, okay, fine, OSHA, come in and fine me, and then I will challenge that fine in court, and I will take this up to the U.S. Supreme Court. That'd be a very expensive proposition. Very few employers could actually afford to do that. Plus, if the ETS survives this Court of Appeals route in the U.S. Supreme Court, then it'd probably be futile to do it, because you already know kind of the outcome, what the outcome is going to be. So unless you're willing to be fined, I would certainly treat it as a law of the land. If the commissioner ends up being required to enforce it, the commissioner will obviously have discretion about, well, I have a certain amount of resources. I got to allocate those resources. I'm going to do the best I can. And so that'll be a question down the road of, if this thing goes into effect and the commissioner feels like his hand is forced to implement it, then the next questions will be, how is that going to work? How's that going to happen? And I think a lot of questions will get answered by that. Keep in mind too, this thing is only in effect for 6 months. What's unclear to me is whether it goes away after 6 months, or if it stays in effect while they're promulgating a standard regulation but on its terms, it expires in 6 months. So that's a little bit of a silver lining, I think, in that it's not, at least at this point, it's not permanent.
We've got to wrap up. And I feel like we're probably leaving our viewers with the impression that, look, there's just as many questions here as there are answers. And that's certainly not our intent. I mean, we do want to sort of put a circle around this and figure out what's on the inside and what's on the outside. Phil, I'll come to you first, and then we'll let the commissioner have the last word. These are folks in the field that have got to make real decisions. You're not sitting on a webinar at 8:30 on a beautiful fall morning listening to this if you're just curious. This is about making decisions for their businesses. What's your last word in terms of advice, I think, but also, what's your best guess? Where do you think this ends up? And then we'll yield to the commissioner and we'll wrap up. I'll make a couple of comments at the end. But Phil, do you mind taking that one first?
Yeah, if I had a business with 100 employees, I'd be scouring the OSHA website. I'd be learning as much as I could about it to try to make informed decisions. I would be consulting with my internal counsel, my external counsel, where things are unclear as applied to your business, to figure that out. Ray, I hope my email will be part of whatever goes out. People can feel free to obviously call me for that. My prediction is that if the Court of Appeals enjoins the ETS, the U.S. Supreme Court will not disturb that injunction. But that if the Court of Appeals declines to enjoin the ETS, the U.S. Supreme Court's not going to affirmatively enjoin it itself. That's my best guess.
All right, Commissioner, I'll let you have a last word here, and then we'll wrap up.
Yeah, just thank you for the opportunity, Ray. Always good to be with you. We are closely monitoring it. I think all that has been said is what can be said at this point. We're going to continue to monitor it on an hourly basis as this thing's in real time. And we'll get through it together. I'm confident of that. And as this thing develops, we are expecting the courts to rule in a rational, reasonable way. But we'll get through it together, and we'll go from there. So I think I'm just going to leave it there for now. I've got you can please send out my email again. We'll make sure we get specific answers on some of these nuanced questions. So
I appreciate that. That's actually our staff had shot me a note over to say, hey, can we take some of these questions and maybe do a little bit of a Q&A guide? And I think that's definitely something at a high level that we'd be interested in doing and having your input on. Just a comment about the chamber. I mean, we sit flatly in the middle of the intersection of law and of business, of policy and business. And it's this kind of situation that puts a lot of cars in that intersection at one time. And we don't want anybody to get run over. We want that process to work together. We know that we need regulation, effective regulation for businesses to operate in a controlled environment where we have certainty. But part of that certainty is regulatory certainty. And it appears, based on just the answers I've heard this morning, that there's still a lot more questions than there is certainty. So we're going to stay engaged. We're going to stay close to the commissioner. We're going to listen to the advice of people like Phil Strack. We're going to try to get you some of that advice and follow up on some of these questions. So we will do that in a document that goes out over the next couple of days. Both of these gentlemen have offered and have in fact left their email information. We'll circulate that. Someone didn't see it in the Q&A box. Josh, yours is over in the chat box. So folks can get that email there. And again, we'll send it out. Very grateful to have had the time and expertise of you two. Really appreciate, Commissioner, in particular, your willingness to come on and sort of set the record straight in terms of what the department is thinking and where your head is at the moment. We look forward to continuing to liaise with you. Phil, appreciate all your volunteer leadership here at the Chamber and certainly your insight today. I think I have a couple of perfunctory comments I need to make here. We certainly hope that you found that today's content valuable. I know that I learned things. I hope you do as well. As you leave, you will get a survey. We'd appreciate any feedback. This is exactly the kind of conversation that we think we're here to have. So any feedback on how this can be improved, we would definitely appreciate that. Again, the recording will come around in the next 24 hours. Thank you for being with us. Thank you for being engaged in the Chamber. Thank you to our members. We can't do this for free. And so thank you for allowing the Chamber to operate in this environment. Most importantly, be well, be safe, have a good rest of the week. Have a great afternoon. Thanks.